Good afternoon and welcome colleagues, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. We are continuing our pre-study on Bill C-23, an act to amend the Canada Elections Act and other acts. This bill proposes amendments to numerous aspects of Canada's electoral law, along with related amendments to the Telecommunications Act, the Electoral Boundaries Readjustment Act, and the Director of Public Prosecutions Act, among other acts. The bill is currently being studied by the House of Commons Standing Committee on Procedure and House Affairs, which has heard from a number of witnesses on certain elements of the bill. Our task as a committee is to conduct public hearings on the subject matter of the bill, which will allow us to report on some of our findings prior to its introduction in the Senate. And for our first witness panel this afternoon, quite pleased to welcome to the committee from Elections Canada, Marc Mayrand, the Chief Electoral Officer of Canada, and Stéphane Perreault, Deputy Chief Electoral Officer, Legal Services, Compliance and Investigation. Welcome, gentlemen, and Mr. Mayrand, you have some opening comments?
Yes.
Please.
Thank you. Merci, Monsieur le Président.
Thank you, Mr. Chair. It's a pleasure to appear today as part of the pre-study of Bill C-23. Because it's a preliminary study, I think that it would be useful to take a step back and provide you with my perspective on the key objectives underlying our electoral process, as well as the important challenges we're currently facing. My hope is that this will assist the committee in assessing whether Bill C-23 helps address these challenges. While I intend to highlight certain elements of the bill in my remarks, I do not plan to enter into a detailed review of the various changes I recommend. I brought a table indicating what those changes are and would be happy to discuss them after my introductory remarks if the committee so wishes. The legal framework governing Canadian elections is a reflection of certain key values or fundamental democratic objectives, namely accessibility, fairness, and trust. In modernizing the electoral process, it is useful to consider these objectives. By accessibility, I refer both to the legal right to vote and to be a candidate in federal elections, as well as to the actual means of exercising that right. Under our Constitution, every Canadian citizen is guaranteed the right to vote. However, that right is made meaningful only to the extent that there is a proper legal and operational system in place allowing it to be exercised. Over the years, not only has the right to vote expanded, but barriers have been removed by providing more options for voters with the aim of giving all Canadians, no matter their particular circumstances in life, a true opportunity to exercise their right to vote. While barriers do remain, in particular for electors with disabilities, our constitutional obligation is to strive to reduce those barriers. It is also our international commitment under the United Nations Convention on the Rights of Persons with Disabilities. A second fundamental objective of our electoral system is fairness. By this, I mean a system where those who compete for electoral success do so under conditions of relative equality. The expression level playing field is often used by the courts and experts to describe our regime of limits on elections expenses, which serves to ensure that elections are not dominated by those with access to greater resources. Limits on contributions in conjunction with public financing similarly contribute to the level playing field. Fairness also means a process for administering elections that is free from partisan bias or the appearance of it. In this regard, fairness is also linked to the third objective, which is trust. The importance of preserving trust in the integrity of the electoral process is reflected in the various procedural safeguards that protect against fraud in the electoral process and that ensure the transparency and reliability of results. Trust also depends on timely and effective enforcement mechanisms that promote compliance with the rules and address cases of noncompliance when they arise. In our system, enforcement is primarily the role of the Commissioner of Canada Elections. Given these three objectives, accessibility, fairness, and trust, what then are the main challenges facing our electoral democracy? In my view, The single most important challenge facing our democracy today is the decline in voter participation. Declining turnout is far from unique to Canada and is not a recent phenomenon. But our participation rate is one of the lowest amongst advanced democracies. The decline in voter participation is mainly driven by the decline in youth turnout beginning in the 1970s. We know from our research that young adults who do not vote in their first election tend to also not vote as they get older. This is why civic education programs are so important. There are, however, encouraging signs. From 2004 to 2011, first-time turnout has leveled off and is showing signs of increasing. At the same time, I can say there are nevertheless electors for whom participation is a challenge. With a rapidly aging population, this is increasingly true of seniors. They tend to be less mobile, have more difficulty with the voter identification requirements, in particularly the requirement to prove their address. This is why at the last general election, I authorized the use of the voter information card, along with another piece of ID, at certain voting locations, namely in seniors' homes, student residences, and on reserves. Building on our experience of the last election and that of other jurisdictions, and also in consultation with political parties, we have been planning to allow the use of the VIC as proof of address, along with another piece of ID for all electors in 2015. This would serve to remove barriers as well as to reduce the recourse to vouching, which has proven complex for election workers to administer. Second important problem for our electoral system arises from the complexity of the rules. Overly complex rules can create barriers to participation or situations of non-compliance that undermine trust in the integrity of elections. This is a problem with respect to the voting procedures, which are administered by some 200,000 ordinary Canadians with limited training and often no prior experience. Our voting process was designed initially and appears simple at the outset, but what has happened since 2007 has made it much more challenging for poll workers. Complexity also presents a challenge with respect to political financing. Again, this is a situation where the rules have become considerably more complex in recent years through successive reforms. And here, the regime relies largely on the work of volunteers serving as official agents for candidates. They are responsible for ensuring that the campaign respects all the Act, and they are ultimately required to account. It has become increasingly difficult for these volunteers to understand and comply with the regulatory requirements. In my recommendations to Parliament, I have strived to identify ways of reducing the regulatory burden and of improving the simplicity and clarity of the rules for the benefit of all participants. This remains one of my concerns. Finally, a third challenge we face is the lack of adequate compliance and enforcement mechanisms to ensure timely and effective, responsive to contraventions of the Elections Act. There is a very heavy and time-consuming approach that is in place. It is ill-suited to the majority of cases of non-compliance that would be more effectively addressed by way of administrative sanctions. In cases that do not warrant an investigation, experience has shown the Commissioner lacks the proper tools to conduct his investigations in an effective and timely manner. Moreover, the fines are not sufficiently severe.
In reviewing the bill, I would invite this committee to consider the impact of this provision on the challenges that I've identified, as well as on the main objectives of our electoral framework. Some elements of Bill C-23 will help address some of our challenges and support the key objectives. The addition of one more advanced voting day will provide more convenience for Canadians casting a ballot. I also welcome the proposed increase of the fines. More importantly, I believe that the introduction of administrative sanctions, for instance, of overspending by political parties or candidates, is a positive development. It's a move away from the traditional model of criminal sanction, and I certainly hope that it will serve as a precedent for future of administrative sanctions, for instance. Bill C-23 also includes a number of reforms which, while positive, require amendment in order to produce their intended benefits. This is the case in particular with the proposed regime for guidelines and written opinions. These would be extremely useful tools, but are unworkable as provided by our amendment in order to produce Bill C-23. Changes are needed to allow rulings to be made in a reasonable time frame. Others are also needed to prevent partisan abuses that could result in if political parties are allowed to require formal rulings on matters that are under investigation or pending before the courts. In addition, if rulings are to be legally binding on the Chief Electoral Officer and the Commissioner, they should be equally binding on the external party compliance auditors. The regime for voter contact services must also be improved. In order to be useful, the regime must not only require information on service providers, clients, and scripts, but must also require the retention and production of telephone numbers that are called. As well, calls made for political parties and candidates by their own staff or volunteers should not be exempted from the disclosure requirements. As it stands, it seems that the proposed regime would increase the regulatory burden on political parties and service providers without significantly improving the integrity of the process and the ability to conduct timely investigation. Finally, a number of aspects to Bill C-23 are deeply concerning, and I feel it is my duty as Chief Electoral Officer to inform Parliament of those concerns in the clearest possible terms. I would like to focus on 5 particular. The first of these are the proposed restriction on voter identification, namely the removal of vouching for electors who cannot provide documentary proof of identity and address, as well as the prohibition on using the VIC along with another piece of ID. It has been argued that all electors should have ID documents to vote, but this is not the problem. The problem for a significant number of Canadians is to have documents proving their current address. The notion that all Canadians have in their possession documents establishing not only their identity but also their current residential address is simply wrong and not borne out by experience. For example, seniors living in long-term care facilities often do not have driver's licenses, hydro bills, or even health cards, which are typically kept by their children or facility administrators. Young Canadians commonly live at home or as students move frequently. They often do not have any documents to prove their current residential address. Overall, we estimate that approximately 120,000 active voters rely on vouching, and we can expect that a large proportion of them would not be able to vote under the proposed rules. Just as importantly, in the absence of any credible indication that vouching or the VIC are used fraudulently, their removal would compromise accessibility without in any way enhancing the integrity of the electoral process. We have not been able to find any other jurisdiction in Canada where a requirement to provide documentary proof of evidence to vote is not also accompanied by a safety net such as vouching or a statutory declaration. Mr. Chair, I have distributed a table that describes the situation for the purpose of voting across all 14 federal, provincial, and territorial jurisdictions across the country. You will know that only 4 jurisdictions require proof of address, and in all cases, vouching is an alternative to providing documents. A second aspect of Bill C-23 that is cause for serious concern is the fact that it will diminish the level playing field in two ways: by increasing spending limits, and more significantly, by introducing an exception for certain fundraising expenses, effectively creating a loophole in the regime. It is hard to conceive of soliciting funds without promoting a party or a candidate. There is also no way of monitoring whether the individuals being solicited fall into the permissible category of previous donors, since the Act does not require reporting the name of contributors who give $200 or less, which represent the vast majority of donors. There is also no requirement to report which contributors were contacted pursuant to the exemption. The fundraising exception is simply unenforceable and is an open invitation for abuse. A third aspect of Bill C-23 that I find troubling is the prohibition on the Chief Electoral Officer providing information to the public on any subject matter except, essentially, how and where to register and vote. Of course, it is important that Elections Canada provide public information on these basic questions. In fact, it should be noted that in the last election, 98% of our communication and outreach expenses were focused precisely on that task. The proposed measure would not simply continue to make this a priority, it would ban all other public communication, effectively prohibiting us from publishing basic research, participating in civic education initiatives, or informing Canadians on fraudulent activities or on measures to prevent them. The Chief Electoral Officer needs to be able to speak freely and openly about any aspect of the electoral process. The restrictions imposed would limit my ability to properly administer and supervise free and fair elections, and it would undermine public confidence in our electoral process. A fourth area of concern regarding Bill C-23 is the weakening of the Commissioner's ability to effectively intervene and enforce the Canada Elections Act. Both the former and the present Commissioner have indicated that the Commissioner's effectiveness depends on having direct and unfettered access to information and expertise within Elections Canada. They are also concerned that placing the Commissioner within the Office of the Director of Public Prosecution would undermine the Commissioner's ability to intervene during an election period in coordination with Elections Canada and election officers to resolve situations of non-compliance. Both have also stressed the importance of amending Bill C-23 to include the power to seek judicial authorization to compel witnesses to testify. They have indicated that the absence of such power has been an important challenge in getting to the facts and major investigation of election offenses. Fifth, and finally, I do not believe that Canadians' trust in the integrity of their electoral system is improved by the addition of central poll supervisors to the list of election workers nominated by political parties. All election officers should be appointed based exclusively on merit, and in particular, central poll supervisors. In my view, this provision should be deleted from the bill. When I look at all these issues and I consider the important challenge that face our electoral democracy, I cannot but conclude that the changes to the bills are required. Changes that include but go beyond issues related to voter identification. I hope that this committee and that the Senate as a whole, in their wisdom, make necessary changes to the bill in order to allow a broader consensus. I believe this is critical to foster trust in our electoral system, and I would be happy to assist in that regard. As I have indicated at the outset, I have brought with me a table of proposed amendments, and I'm certainly open to exploring other alternatives with the committee. Mr. Chair, I would be pleased to answer questions. Thank you.
Thank you, sir. And we'll begin those questions with the Deputy Chair of the committee, Senator Baker.
Thank you, Mr. Chairman, and we thank the witness, probably the most important witness we'll hear from concerning this legislation, the Chief Electoral Officer. Now, you testified a few moments ago that when the rules changed in 2007, that it made things more challenging for poll workers and that some irregularities would have occurred. The evidence that we've heard before this committee this morning was that there were 50,000 irregularities in one case, and there was over 100,000 irregularities in another case concerning the last federal election. Now, you would know about those irregularities because you're the only person who has the authority to reopen those sacks that contain the evidence. I noticed you said estimate, so I imagine you didn't count them all. You made an estimate.
Yes.
And that 120,000 were vouching.
Vouch for.
Now, in all of those errors that were made, did you see any evidence or do you have any evidence to give to the committee on how many of those errors actually caused somebody to vote who should not have voted or fraud during that election campaign?
This whole matter is of errors came through a case, the Etobicoke election, which was contested and went through up to the Supreme Court of Canada. In the course of that case, there were issues raised regarding voter registration and voter vouching. A number of errors were pointed out to the courts in those cases. And in the end, the Supreme Court of Canada said that bookkeeping errors are not irregularities in themselves. And the vast majority of issues that were found were bookkeeping errors. So improper bookkeeping by electoral workers. There was no indication of two things. No indication of any malfeasance by workers. Secondly, the court was satisfied that there was no reason to believe that any ineligible electors would have been allowed to vote.
That's the important point, isn't it? Because that's what...
I would think so.
Well, you would think so. Mm-hmm. So all of these irregularities, probably involving a long-term facility in which the nurse probably vouched for a patient. Mm-hmm. Am I giving a good example here?
Yes. In a case, a nurse vouched for 29 electors.
Just imagine. Now, that's an irregularity. Shouldn't have done it.
No.
But no doubt that person had a right to vote. Now, let me get to the very important statement you made a minute ago. And I'm going to quote you. Because this is the disturbing statement you've made in your presentation. Overall, we estimate that approximately 120,000 active voters rely on vouching, and we can expect that a large proportion of them would not be able to vote under the proposed rules. You are telling this committee there's going to be tens of thousands of people who are eligible to vote in the last election, but with the passage of this bill will now not be able to vote.
Yes, because it's the only safety valve or fail-safe provision for people who are challenged in proving their identity and address. The only fail-safe provision is vouching.
And you
taking
use the
it
word,
away
yes,
eliminates the fail-safe.
And you use the word fail-safe because, as I recall, in a BC court decision, that was the evidence that vouching was a fail-safe to somebody who didn't have the necessary documentation. Is that correct?
You're referring to the Henry case, I believe. Yes,
I'm correct. So, Section 3 of the Charter, you cannot deny somebody's right to vote. So this legislation, if we are to take you on your word, you have reasonable grounds to believe, to suspect, on a balance of probabilities that tens of thousands of people will not be eligible to vote who voted in the last election, then it violates Section 3 of the Charter.
Well, I think that's a matter for you to consider as parliamentarians as well. If a matter is brought before the court will have to determine whether it offends or not Section 3.
Well, you're going to be the respondent. You're going to be the respondent in the court case.
I'm going to be a party, but the Attorney General will be the respondent and defending.
But you're now agreeing with the applicant Because you're saying yes.
My role before the courts is to advise the courts of the current provision of the legislation, how we interpret it, and how we apply it, and provide an information that may assist the parties and the court in determining whatever the issue is at hand.
Good answer.
Here, Senator Baker.
Good answer.
Move on to Senator Frum.
Thank you. Just to continue with that vein of questioning, you've taken the position that of the 120,000 estimated vouchers, we don't know. That's from Neufeld's report.
No.
It could be less, it could be more, we don't know.
It's based, there was a methodology applied there, but it's based on 1,000 poll books being opened from a cross-section of representative riding and polling station across the country.
But by asserting that those approximately 120,000 people are going to be disenfranchised, it means that you know that they have no other form of ID. Can you say with certainty that you know that they don't have ID, that you know the reason why they were vouched for?
I can think of a few examples. The most, probably the easiest one, is with seniors living in under-care facilities. Often they don't have documents.
But on that point, and to the 29 cases by one nurse, that's inappropriate. But the administrator of that long-term facility can write a letter of attestation that they live there, and that solves their problem.
Yeah, that leaves it to the goodwill of the administrators. In some cases, unfortunately, for very good reason, they have refused to provide those letters of attestation. There's no obligation for them to provide that. So we rely on their goodwill and try to negotiate a way of making it happen. But in some cases, for all sorts of good reason, it's not possible.
Moving to a different subject, your concerns about removing, from Section 18, removing your ability to participate in future and get out the vote initiatives. I want to ask you, do you not see why there is a conflict of interest between you as a chief electoral administrator being in charge of the administrations of free and fair elections, and also you being invested in get out the vote initiatives, so that you have then a vested interest in seeing the numbers increase, and that balance between you needing to see that things are free and fair and you as a motivator to get out, to make sure that voting increases, you don't see the conflict there?
I wouldn't say that we're involved in getting the vote out. That's not what we're doing. We don't do any of those activities during an election. But in between elections, we work with educators across the country, with various groups. We provide tools in schools to help provide the civic education for young Canadians. Generally, those initiatives have been very well received by teachers, by schools, by parents, and by kids. There's even some data that suggests that those kids who have gone through those civic education are 14% more likely to vote if they have gone through a proper civic education.
Yeah, I agree with you that civic education is important. I'm just questioning whether or not it's properly housed with Elections Canada.
My point here is that it should happen. I think it's essential that we inform future electors regarding their role in society and community and the importance of voting. If it's done by others, I'm fine. I think it's something that is required a concerted effort of the whole civil society.
But you have said that the measures in Section 18 will limit your ability to properly administer free and fair elections.
Yes.
So is that really, can you really extrapolate that we will not have free and fair elections if you can't do those civic
My
promotions?
concern is that the way the new Section 18 is written, it's written in a restrictive manner. The operative word in that section is only. Can only communicate with the public with how, where to vote and register or be a candidate. During an election, there's all sorts of incidents that happen where I think it's important to reassure Canadians that something is wrong or that something is fair. And I think if nobody can speak out to those issues during an election, I think Canadians may become quite concerned about what's going on. I'll give you an example. I assume you followed the Quebec election recently. There was quite a dispute regarding potential non-resident trying to register and vote in that election. And that's what we do. Within 24 hours, we looked at all the data available. We're able to satisfy or reassure the public that there was nothing amiss going on. That's the sort of thing that an electoral body has to have the ability to do. Otherwise, confidence,
And why do you think that would no longer be allowed, that particular
because
example?
I cannot communicate on anything except where and how to vote.
But
that's 18.
And who? And who can vote? You can communicate on who can vote.
I'm not sure that's what it says.
It is, but okay. Thank you, Chair.
Senator Joyal.
Mr. Chair, bienvenue, Monsieur Mayrand.
Welcome, Mr. Mayrand. Mr. Mayrand, I'd like to first of all come back to the issue of vouching. Let's keep the English term. In your statement to the House of Commons, when you appeared as a witness in March last, on page 4 of your proposal, you said, I don't know if you have it in front of you, but I'll read the paragraph. It's the second last paragraph on page 4.
Procedure, and that numerous procedural irregularities were found to have been committed at the last general election in connection with vouching. It is critical to understand that, as recognized by the Supreme Court of Canada, the vast majority of these were strictly record-keeping errors by poll workers documenting the vouching process, not fraud or even irregularities that could compromise an election. There is no evidence tying these errors with ineligible electors being allowed to vote. Ce qui me préoccupe.
What concerns me in the bill is this. It is the fact that there are requirements by which you must identify yourself when you go to the polling station. I quite agree with that. But if you do not meet those exigencies, there is a process, an emergency process, the fail-safe of vouching. In certain provinces, it's an oath that is taken where you swear that you are that person. This emergency option that exists in a system, could it not just be improved rather than have it quashed, have it removed? Because, as the Supreme Court said in Ranofsky, 2012, and Oppitz, in the Oppitz case in 2012, could you not rather seek to improve the system, the vouching system? Because, as you have said, that there are administrative errors that occur. Wouldn't it be better to improve that system rather than just to get rid of the system, whereby you could prevent thousands of persons from voting because there is no fail-safe? You can imagine what the result might be. Yes, there are several alternatives. One of the things that was proposed by the Neufeld report could be used, because you have to remember the essential proof is always the matter of proof of residency. It's the proof of current residence that is the issue, the nub of the issue here. One thing that could be done, and it was proposed to be able to use this emergency off-ramp, would be to have the voter identification card used. And in other jurisdictions, that's done in BC, and it's done in Saskatchewan. That's what is done when somebody turns up at the polling station without proof of their residency at a given address. There are other solutions that were proposed by my predecessor. But that was Neufeld that proposed this. Yes, using the VIC. It is in the Neufeld report, but it is also the practice that is used in Saskatchewan and BC. Another solution that was proposed by my predecessor in giving his evidence before the House of Commons is to use a signed form. This is another possibility. Elsewhere, they use provisional ballots. In other words, the ballot is pending until after the election the identity of that voter can be established. That is another type of solution. But I just want to stress this. The requirement for proof of at your address is not much used in other areas, other jurisdictions. It's true for Canada in certain areas and in some countries, but in the United States, if you wish to compare with the United States, they have requirements in terms of proof of residency, but of identity, proof of identity, but there is only Arizona that requires a proof of residence. So it is somewhat rare, quite rare in the majority of electoral systems. And I think it's for a very good reason. It is very difficult for many voters to prove their current place of residence. So what I therefore draw from your presentation is this. The argument that the vouching system is not a cause of electoral fraud. It is not endemic in the system. No, it's not at all pervasive, as we say in English. It's not in all the systems in all the regions of Canada. It is not perceived by fraudsters as being an open door to change the outcome of an election. Yeah, it would be quite difficult to defraud in that way. There are other areas that could be used, but voters have to be in the same registered in the same voting area, in the same riding, and it would be quite difficult.
Very much for attending our committee today. I'm from Saskatchewan, and the first thing that I wanted to ask you about, I noted your testimony before the House of Commons Proc Committee, and you made a comment that First Nations electors on reserve also face challenges as the Indian status card does not include address information. But I would say that there is a safety valve for that sort of a situation, and that we allow, as one of the 39 pieces of identification, which goes to show residence, attestation of residence issued by the responsible authority of a First Nations band or reserve. And I would also put to you that there are a number of other safety valves, as you put it, dealing with those similar types of attestation forms, which would be issued by the responsible authority of a shelter, a soup kitchen, student senior residence, or a long-term care facility. So any of those types of forms of identification could be used in situations where many of those particular groups often do have trouble finding the regular forms of ID, but those are a number of safety valves. Would you agree with the use of that term? In
fact, I introduced the list of authorization, attestation into that list in 2007, recognizing it was a problem for many electors. The problem we've seen in administering it is that not all authorities are cooperating in providing those attestations. So it puts the elector, if you want, at the mercy or into the goodwill of whoever is the administrator. True. In some cases, they are very busy. In some cases, they have thousands of people to attest to. So it's difficult to get cooperation, in my mind, in too many instances, to rely exclusively on that provision.
From my past election experience, sir, I would say that though it's a very widespread practice that those types of attestation forms are commonly issued. Would you agree with that?
They are often issued, yes. But again, universally, no.
No, commonly, though, in a widespread practice.
Mm-hmm. Yes, but again, it's an individual right at the end of the day. It's
you also spoke at the House of Commons Proc Committee, and again, you addressed it today, that in your view, the main challenge in democracy in Canada today is voter participation. And today you spoke about the main challenge being the decline in voter participation. And in my view, we spoke today about the youth vote being something that was alarming. And there was an Elections Canada report. It investigated youth participation rates in the 2011 general election. And in that particular report, youth non-voters expressed that not knowing where, when, or how to vote played a role in their decision not to vote. Not knowing where played a role in 25% of cases, when 26% of cases, or how 19% of cases. So what would you say to the fact that then that, it seems to me, that should be your main priority is helping people?
Two things. I would point out that 46% also said the lack of contact with political parties and candidates is a major factor for them not to participate.
So that's for the political parties to address then, yes.
The second thing is that when you look at surveys, you have to go a bit beyond the top-of-mind responses. When we do a regressive analysis on the results of their survey, and it's in that report, you would find that two main factors that affect turnout. The first one are what I would call barriers, access barriers, like not knowing where to vote, and motivational barriers. The study will also tell you that the most significant one, by far, is motivational. To generate an interest in learning about how, where to vote, you first need to be motivated to participate in the process. If you're not likely to pay attention. As I indicated earlier, in fact, 98% of our efforts in terms of reach out is to inform electors about the requirements for voting and where and how they can cast their ballot and the options they have in casting their ballots.
Okay. Another aspect that you dealt with at the House of Commons Proc Committee was your preference for the use of voter information cards. But you also indicated to that committee that there was up to a 10% error rate on those voter information cards. I know that I personally have experienced that when my husband and I first lived, several years after we had moved into our current home. We received in the mail 5 different voter identification cards. I believe there was one for him, one for me with my maiden name, and one for each of the previous owners of the house who hadn't lived there for several years. So there's one example, but I'm just asking for your confirmation. So if you testified before PROC that there are 23 million voters in Canada, so up to a 10% error rate would be 2.3 million errors on voter information cards.
I think I testified also that after revisions and targeted revision, that rate of accuracy goes to 93%. And you're right, there's
so it's
still 7%
out of millions of people. Yes.
One of the things that may explain why you receive so many things, first of all, you may have used different names depending on our sources, could be driver's license, income tax, or other sources. The other thing is that you will note that the card is sent to a name or whoever occupies the dwelling. In making the VIC available as a proof of address, we would have to change that part of the card to make sure that it only goes to actual occupants of the dwelling.
We'll have to move on. Senator Boisvenu.
Monsieur Mayrand, bonjour.
Good afternoon, Mr. Mayrand. Thank you for your presentation. I have 2 questions for you with respect to your brief. On page 12, where you say that the current commissioner and his predecessor both indicated that they have to have direct access. They fear that the transfer of the commissioner's office to the public prosecutor would limit the capacity for him to do his work. But when I read your brief, it doesn't seem to me that there is a certainty of this happening. Do you have any other arguments that might shore up your position, other arguments to convince us, or Is it just something that is a concern? You know, nobody likes change. We fear change. But can you reinforce this? Well, listen, there's going to be a separation of the administration of inquiries. Presently, there is no method of communication between the two entities for the future. That means that the elections commissioner would be in the same position as any other complainant. And say a government agency, therefore, would be subject to other regulatory requirements of other government agencies, which limits the exchange of information between governmental agencies. I think that this is a gap in the thinking. I should be obliged if the commissioner asks me to provide information to do so. I should be obliged to see that he has the tools that he needs to conduct his investigations. Yeah, but we're talking hypotheses now, are we not? Does that mean then, is this the reason why your brief did not include a proposal that would flesh this out? It's in the tables that I gave you. So this is a concern. You fear that this could lead to difficulty. No, I apologize. It is covered in the table itself with respect to my objections. With respect to the percentage of vote, on page 4 of your brief, you dealt with your mandate for information. That being said, there has to be... you did not lead a certain part of a paragraph on page 4, which is the second paragraph on page 4 that is being alluded to here. Well, no, I didn't think it was necessary. Well, now let me turn to the participation of youth, the youth turnout for voting. That represents some 2% of your expenditures. Isn't there a contradiction if you're only spending 2% on that area, and yet there is a low voter turnout? Isn't there a conflict here? Well, there are some 3,500 schools throughout the country where we have information sessions. Many of the candidates are invited to make presentations, to present their positions to the students in the schools. Well, what is the percentage of your 33 million that you spend in terms of information for 18 to 20-year-olds? Well, it's spent on all voters. But you're saying the problem is that you've got to improve the youth voter turnout. So what percentage of your budget is expended strictly for that purpose? I look at the election in Quebec, where the elections commissioner was very, very pointed as to the need for dealing with this. So my question for you is, what percentage of your budget do you spend on that? I don't have the figures with me, but I can provide you with those figures. Though the money's targeting young people. In all the major campuses in this country, there is an outlet to inform them about their options for signing up to vote, the alternatives, how to vote, and when they should vote.
Thank you, Chair, and thank you, witnesses, for being here. I just want to follow up on that questioning, Mr. Mayrand. So, student vote costs less than $800,000. Do you do this work to encourage and to inform the students, the young adults, about their right to vote and the importance of it? Do you do that between elections, or is it only at election time?
No, we do work with schools and teachers across the country between elections.
You do?
For example, we did, in collaboration with Elections Ontario, develop a curriculum on civic education that's distributed in all schools in Ontario. And that's been well received. It's been evaluated, well received by teachers and students alike.
Okay. You talked about the 120,000 approximately voters who would miss out the opportunity to vote because of the removal of the voting system. Do you have any idea of what makes up that aggregate, whether they're First Nations people, whether they're street people, whether there are veterans among the street people? Mm-hmm. Do you know who makes up that?
Honestly, we do not, because we don't keep information on electors, other than if they have voted, that's in the poll book, who has vouched, who was voted for. As to what were their particular circumstances, we don't know about that necessarily. What we can tell from what we've looked at, it's often relatives. So it's people living in the same dwelling, and a mother and adult children that would be vouching for one another. It's often also where seniors live with their children. Children would vouch for their mother or father or other relative. That's the majority of cases, but we don't again have exact profile. We know it's an issue on Aboriginal Reserve. We know it's an issue in senior homes. We know it's an issue also for students.
You've made some very good recommendations and acknowledged the issues that are facing the election process in Canada. What involvement did you have at the request of government officials or otherwise in connection with the preparation of this bill?
Well, my involvement has been through the production of various reports since 2010, at least 3 that were produced and tabled in Parliament. Other than that, we've had no involvement in developing the current legislative
So when this
proposals.
bill was prepared, you had done reports in the past.
Yes.
Nobody came to you and said, look, you've done a lot of work on this. What do you think? Are we headed in the right way? Are we opening up for more Canadians, or are we going to be suppressing? Did anybody ask you about that?
Never been asked about vouching and the phenomena of vouching and how it was an issue, or what would be the alternatives or anything of that nature. No.
The thing that bothers me about this whole operation is a matter of robocalls. When I think of people being directed to the wrong places to vote, Canadians, I mean, we've got men and women who fought and died, and they're buried in other countries to protect democracy, to protect this right to vote, and now we're suppressing it. Why do we have that? Why do we permit that? Why don't we get rid of that? It's repugnant to our whole system.
Well, there are some provisions in the bill that seeks to deal with events like robocall. I think there are some improvements that are brought into the bill. I pointed out that there's still room for further improvements. There's a few issues that I see with the regime that's being proposed. But again, as I indicated, I think it's, to me, it's in the range of provisions that are good but could be made better through discussions around
You mentioned some of the... I've got one more question, Chair.
Well, I'm afraid you don't have time for one more question. Senator McInnes? No, you don't.
Thank you, Mr. Chair, and thank you for coming. There's several points in your brief that I wanted to touch on. I'll try to do it very quickly. Voter decline is a real problem, and it's a real challenge. Motivation you've alluded to or mentioned directly, and it's something that I don't know how you change it. There's a lot of frustration. Comments that they're all the same. I think it's probably because there have been too many Liberal governments in this country has turned people off. But it is a challenge. But in sincerity, you haven't accomplished perhaps what you set out to do, because it's a major challenge to get the vote up. So I agree with what this bill is doing with respect to that. Now, I just want to touch on this. You mentioned that the commissioner will not have the tools to carry out his job. And you mentioned as well that I take it, I don't think I saw it in here directly, that you removing the commissioner out of your office is incorrect. You'll correct me if I'm wrong on that. But that's what I take. And and other comments with respect to witnesses that cannot be compelled to testify. It displays, and please, I'm not being arrogant, and I'm not being smug, and I'm not taking a shot, but it does display to me that you do not have an understanding of how the justice system operates is with respect to independent public prosecution and directors. I am amazed that in 2014 we would have the management of elections in this country and regulation and enforcement in the same office. That is appalling. In fact, this is an excellent move, and I'm amazed that it has not been made prior to this time. Mm-hmm. And so it is, and you know, comments, other comments that I've read in the media is quite shocking and quite surprising, because compelling witnesses to testify after the investigation is done will be done by the director of public prosecution or those that work under him. With respect to investigations, the commissioner will now be charged with the responsibility of hiring the staff and will hire more staff to conduct investigations. And one other comment with respect to communications, I rather suspect that during an election, if there's something untoward, that the commissioner will comment if necessary, and if it's not in breach of any pending charges. So that's what's troubling to me, is that there just seems to be this misunderstanding of the responsibility of our true justice system in getting and separating out. As has not only been fashionable across the country, it has been almost mandatory, and as I said earlier today, with rural commissions where millions of dollars have been spent to determine these things well back in the 80s. Yes.
Mayrand, respond.
Please.
We're running out of time here.
Yep.
Mr. Mayrand.
You raised several points. I'll try to touch briefly on a few. What's unusual is merging investigation with prosecution. The tradition in Canada is to keep separate investigation and prosecution separate. In fact, I'm not aware that the DPP has any other responsibility regarding investigation than the one that has been given by this piece of legislation. That's one thing. The other thing, it is common, both at the federal and provincial level, to combine within regulatory agency responsibility for investigation and administration. You can think of CRA, you can think of the Environmental Department, you can think of a plethora of agencies that combine those two functions. So I'm not sure. In terms of resources, there's nothing in the Act that brings or adds or subtract resources. In terms of the history, again, what was done in 2006 was to separate, because that was unusual, having combination of administration, investigation, and prosecution. That was unusual, and that was fixed in 2006 by moving prosecution away from the Commissioners of Elections Canada. It seems to me we're going in circle here. We're now saying 6 years later we need to bring investigation with prosecution again. I leave that to the committee to decide.
I'm afraid we have exhausted. We have other witnesses scheduled, and I'm afraid I understand Mr. Cote is going to be appearing before us, so you'll have an opportunity to pursue that issue further. Gentlemen, thank you very much for your assistance.
Monsieur le Président.
Chairman.
We're going to recess for a few minutes and then hear our next witness.